opposition to constitutional reform. One, they're talking about reform, and the other is talking about the new constitution that separate. Both may have some merits, both may have flaws or limitations, etc. But the existing constitution, the first chapter, Article 1, I just want to read this to you. The said that Guyana is an indivisible, secular, democratic sovereign state in the process of transition from capitalism to socialism and shall be known as the Cooperative Republic of Guyana. Well, that is clearly unnecessary, superfluous, and it has no place in the Guyana Constitution now. What if I were to write a constitution? I don't want to argue onto myself that, but I'll just suggest something like this. We replace that with, we say that Guyana is an indivisible, secular, democratic, sovereign state that is transitioning into an indigenous, one Guyana capitalism with a human face, where fairness would prevail in all aspects of life. So I leave it to you now. That is my thought about that, but I have a lot of other questions about other parts of the Constitution. So go ahead, AG.
Well, permit me to thank you for inviting me to be part of your discussions this evening. And I'm happy that you have chosen the very important topic of constitutional reform. As you may be aware, constitutional reform is a PPP manifesto promise, as it is a manifesto promise of almost every political party that contested the 2020 regional and general elections. The PPP went to the electorate with many promises, including that of constitutional reform, but also went a bit further in articulating how these reforms will take place. We said that we will follow previous PPP initiatives in respect of constitutional reform, and that the reform will be based upon consultation with the populace and important stakeholder organizations. And importantly, it will be driven by a broad-based constitutional reform commission comprising of 50% parliamentary parties, that is to say 50% politicians and 50% civil society organizations. These organizations include labor, religion, private sector, indigenous groupings, organizations representing farmers, organizations representing civil society organizations such as the Guyana Bar Association, etc. So we have already put before the National Assembly and enacted a Constitutional Reform Act capturing these tenets which formed part of our manifesto promise. We recognize that meaningful constitutional reform cannot take place in our constitutional construct without the opposition coming on board, because every important provision of our Constitution requires a 2/3 majority vote in the National Assembly for there to be any change. So, recognizing that, we took that bill to a select committee comprising of government and opposition, and we had a consensual bill coming out of that standing committee to which the bill was sent, and the bill was then placed in the parliament and debated. Unfortunately, I cannot recall. Oh, I believe the opposition did not participate because at the same time, or on or around the same time, they decided to boycott Parliament because 8 of their members were suspended for misbehavior at a previous sitting. So we commenced the process on that unfortunate note because, as I said, the process cannot yield any appreciable success unless we are able to get on board the parliamentary opposition. Why should the process be a consultative one? Because we feel that no segment of our population or no political conglomerate has the monopoly over what our constitution should embrace, what its terms should be, and what the concepts of that constitution should embrace. A constitution is really a pact between the populace and the state, whereby that contract between the state and its people must capture the aspirations, the dreams, the ideals of the people. It must guarantee to the people certain inalienable, recognized human rights and freedoms. It must outline the relationship between the state and the people, in particular, in relation to the style and system of government and how that system of government must function, how that system of government must change. So what are the essence of the electoral system? It must also contain a series of safeguards that will ensure that if a government misbehaves or any member of the state apparatus misbehaves, then there must be sanctions to ensure that such misbehavior is not countenanced and indeed punished. It must also embrace, as a democratic state, the principles of separation of powers. It must guarantee the independence of a system that will allow for law and order to prevail in the country and to which the citizens can turn for justice and for enforcement of the laws of the country and the constitutional precepts and concepts ensconced in the Constitution. In short, it must have a judiciary that is functioning. It must have a parliament that is participatory, meaning that it must allow for all the elected representatives of the people to participate in decision making, in the making of laws, and most importantly, that Parliament must be able to oversight government receipt of revenues, expenditure of revenues, government's fiscal policies, and generally, Parliament must be able to oversight the manner and form in which government is executed. Those, in my respectful view, are the essential concepts and tenets of a modern democratic constitution in a system like ours, where the constitution is the supreme law. So,
Okay. I
now
just want to ask
you
you
are
to start.
articulating, let me just conclude this. You are articulating your own personal formula. And while that may be commendable in the manner in which you expressed it, the truth of the matter is that our government philosophy and our government's approach to constitutional reform is not one that will impose our government's view, but will take on board what the majority of the consultations or the recommendations that the consultations will produce.
No, I understand that. The issue with separation of powers, that's not so clear because members who are parliament in the legislative branch are also members of the executive. And so in terms of conflict, I can see the judiciary being separate, but the executive and the legislative are closely intertwined.
No, you're perfectly correct. And that is a recognizable reality. The Westminster system, which we have inherited from the United Kingdom, allows for a coexistence and an intersection between a coexistence of and an intersection with the executive and the legislature, because the way in which the legislature is structured constitutionally is that it comprises of members of the executive as well as members of the elected opposition. Together they constitute the legislature. So yes, indeed, there is an incestuous relationship, if you wish, between the executive and the legislature. But that is acceptable in the entire Commonwealth. But as you pointed out, it is of paramount importance that the judiciary remains separate and apart to ensure that it is allowed to adjudge over the other two poles of government. So
okay, thank you.
That's why our constitution allows for all matters relating to the judiciary to be insulated in a degree of independence and autonomy that prevents any form of interference either by the legislature, the executive, or indeed any other organ of state.
Now, going back to the structure of your constitutional reform body, you said 50% MPs and 50% others from civil society, etc. Now, how does this, what's the interaction between this and the Standing Committee of Parliamentary Reform? Are they the same or they're linked to one another? So, how that operates?
So there is a Standing Committee on Constitutional Reform. It is this Standing Committee that engineered the bill that led to the establishment of the Constitutional Reform Commission. That commission will do the constitutional consultation or the consultation in relation to constitutional reform and will prepare a report that will go to that standing committee. And it is that standing committee that will refine and crystallize those submissions to put them in the form of amendments for the purpose of the Constitution, or the purpose of the National Assembly, rather, to become amendments that will eventually reach the floor.
They're supposed to process. Are you saying they're supposed to process the results, the feedback that they get from the?
Yes, the Constitutional Reform Commission, after holding consultations countrywide, will prepare a report which contains recommendations for reform. Those recommendations now will have to be refined and crystallized and drafted in the form of constitutional amendments that will eventually reach the floor of the Parliament. Now, significantly, I do not see a prohibition against members of the Standing Committee on Constitutional Reform not being able to be part of the Constitutional Reform Commission. I believe that you can have that. It's
Okay.
just that a different cap would be worn
Yeah.
at a later stage. And in fact, I believe that it would lend to greater fluidity and greater smoothness if one can interchange one's hat in the manner and form that I've articulated.
Yeah. Thank you. I'm glad you clarified that because that was creating some confusion. Now I pass you over to Professor Mahin.
Sure, Dr. Tara. Thanks, and good evening, Attorney General Anil Nandlall.
Good evening.
You spoke about the important role that the opposition has to play in these consultation and the constitutional reform process. But given their lack of participation, how do you foresee that process moving forward with a degree of bringing radical changes to the Constitution, where you have a level of participation and a constructive level from the opposition? And secondly, you spoke about the process of this reform being held out of consultation, but given the commission of inquiry that's ongoing around the recent election, are there going to be consideration from those reports as well as for findings in constitutional reform considerations?
All right, so you have asked me about three questions there in one. So, what role the opposition will play?
Yes.
Now, I can only speak for my government and I can only speak for my political party. What I can say as well is that it's public knowledge that the opposition also, like the government and like the People's Progressive Party, promised constitutional reform. We are going to discharge our promise as far as possible and as far as the law and the institutions permit. And if we don't get the requisite partnership and support from the opposition, well, then so be it. We simply can't move beyond that. The electorate, however, will have to treat with that matter because the opposition, I presume, will have to go back to an election and they will have to answer to the electorate why they have not delivered their promise. We, on the other hand, would be able to stand and say proudly that we have done everything within our remit to deliver upon that promise. And that's all that we can do because of the bipartisan nature of the exercise. Also implicit in the behavior of the opposition, which I would like to highlight and which we will highlight, is their institutional tendency for disrespect or institutional tendency of disrespect for the Constitution and the rule of law generally. This program will not allow me the time to cite all the instances of violations of the Constitution because I've done so many times. The unlawful appointment to the chairman of GCOM in the form of partisan, disrespect and disregard for the Constitution in relation to the no confidence motion, the disrespect of for Guyanese rights who are resident overseas by their constant attempt to scrap the existing database and disenfranchise all those persons of their constitutional right to vote at an election, their flagrant disregard of the Constitution and the relevant statutory provisions as they attempted for 5 long months to rig the 2020 elections, the complete and utter violation of the constitutional rights of Guyanese citizens as they revoke their leases, and I can go on and on. So equal to constitutional reform is constitutional compliance and compliance with the rule of law generally. So not only has the opposition evinced a clear and settled penchant for disregard of the Constitution and disregard of the rule of law, but now we are seeing their apparent disregard for their promise to the electorate of delivering constitutional reform. Permit me to say that constitutional reform has not been a new item on the manifesto agenda of political parties. Almost every political party going to elections in recent times have made this promise. In 2011, for example, when they won a one-seat majority, they promised constitutional reform in a major way. They got a one-seat majority at those elections and they controlled the parliament. I was the Attorney General. They took over the Standing Committee on Constitutional Reform and they gave Leader of the Opposition, David Granger, to chair it. And I don't think in that 4-year period, more than one meeting was held with David Granger as the chair, and they took control of the majority of that Standing Committee on Constitutional Reform. So they abysmally failed there again. Then they won the 2015 elections and they formed the government. Again, constitutional reform was a fundamental promise on their agenda. When they got into government, they, through the Prime Minister, Moses Nagamootoo, they commissioned a constitutional reform report to be done. They appointed Nigel Hughes and about 2 other persons. I believe they paid some $20 million. A report was produced by this team that was handed to Nagamootoo, and it never saw the light of day after that. We were not consulted at all by that grouping assembled by the then government. The Constitutional Reform Standing Committee of the National Assembly was chaired during that period by Basil Williams. I don't think we met more than twice. And nothing was done, not a single line changed in the Constitution. In fact, no serious preparatory steps were made towards that, the achievement of that objective. So I took the time there to give you the antecedents of the opposition, both in terms of constitutional compliance as well as in relation to their promise in respect of constitutional reform. But as I said, we can only do that which is available, which we can deliver. The last issue that you raised is whether the report that is likely to emanate from the Commission of Inquiry will be taken into account for the constitutional reform process. Certainly, it is an important report. It is going to be the most authoritative statement coming from a judicial or semi-judicial body in relation to the elections, save and except the pronouncements that we have had in relation to cases arising out of those elections at every level of the hierarchical structure of the judiciary in our country. This commission report will add to that volume of jurisprudence in relation to the behavior and conduct of those implicated in that electoral saga. Insofar as that report makes recommendations of a constitutional type and nature, of course, a prudent constitutional reform commission will be obliged to take those recommendations and that report into account.
Mahendra, you have a follow-up?
Thanks for the answer there, Attorney General. Given the nature of the judicial, we saw some very surprising judgments in the appellate court, for example. In this constitutional reform, are there consideration for a judicial review body? For example, United States, judges are held accountable for their conduct, etc., and then their actions to follow. As the diaspora, we were very surprised with some of the interpretations we saw around the election period, and we want to make sure while this comprehensive process is ongoing, what is also on the judicial side of holding that body accountable?
So let me assure you that the diaspora was not unique in its interpretation of some of the decisions that would have emanated from our courts during that period. I believe that I'll be accurate in asserting that the world was aghast and shocked at some of those rulings. Let me also say to you that there is no sacred cow in today's modern democracies. There was a time, perhaps, when certain components of the state apparatus may have been viewed differently. That has changed. Once public funds are used to finance institutions, then they must be accountable, and modern democratic protocols and standards would hold them accountable. There are mechanisms in place that hold the judiciary to certain standards. The judiciary is as a highly self-regulatory body, but like every other institution in the modern world, it is answerable and must be held accountable for the manner in which it conducts itself and the manner in which it conducts its business. So speed and efficiency are part and parcel of a justice system. You must be aware of the aphorism, justice delayed is justice denied. So we have had a law in Guyana for over a decade or more that requires judges to deliver their decisions within 6 weeks after the close of the final submissions in a case, and also to do a report in terms of their compliance with this legislation and lay it in the National Assembly annually. That legislation has been completely ignored. Now, going forward, we cannot continue in this vein. Currently, I will admit that we have shortages of judges and we don't have a Judicial Service Commission appointed as yet to ensure that these vacancies are filled, both at the level of the judiciary and at the level of the magistracy. But every effort is being made to establish this important Judicial Service Commission. But once that is done, we have a bill currently in the Parliament intended to increase the number of judges at the Court of Appeal threefold. So we are going to appoint an abundance of judges required for the task at hand. But once we accomplish that, then I believe that the judiciary should be held accountable, and those laws will have to be enforced. The law, for example, that I'm speaking about, and persons' constitutional right to have a fair trial within reasonable time. Now, no area of the Constitution is exempt from review in the impending exercise. So the judiciary is an important constitutional institution, and that will also be the subject of review. The way the judiciary functions, having regard to what you have said, and you, as I said, you are not in isolation in any form or fashion in the view that you have expressed. In the same way that the executive is under pressure to be more accountable, to be more efficient, become more transparent in its daily functioning, the same way the parliament is being pressured to deliver more legislation, to have greater scrutiny over executive conduct, for the Public Accounts Committee to delve deeper into the Auditor General report so that financial irregularities are exposed and persons are charged. And the same way that we are increasing Parliament's ability to interrogate the executive, well, the same way the judiciary has to be made subject to similar initiatives in order to extract from it the level of transparency and efficiency that is consistent with modern realities in a democratic society.
Thank you for that.
Let me just ask you a follow-up question there, AG. Is there a policy of you have a sentencing guideline in Guyana?
Yes.
I know in the US you have policy guidelines of specific offenses with a minimum and maximum.
So you have basic principles that govern sentencing, principles of law. Sentencing is a legal concept and is a legal exercise. And like every other legal exercise, there are rules governing how this power to sentence ought to be exercised. So you will have you have the various laws, the statutes, which create these offenses, and they would stipulate sentences, meaning between X year and X year for a particular offense. Or if it is a capital offense, then perhaps the death penalty or non-custodial sentence. So you have legal guidance in the form of statutory mandates which address the question of sentencing. Then you would realize that even in those statutory formulations, the judges and the magistrates who are expected to administer these sentences are given discretions. In law, discretions are never untrammeled or absolute. Discretions are always regulated by principles, by a sense of reasonableness, by the tribunal not taking into account irrelevant factors, but must be guided by relevant factors. So, for example, principles such as proportionality will apply to sentencing. So the gravity of the wrong perpetrated must bear some reasonable relationship with the penalty that is going to be imposed. You can't have a grave wrong carrying a non-grave penalty, for want of a better word, or a knock on the wrist. So you have to have these reasonable relationship of proportionality and some degree of commensurateness between the type of crime committed and the type of punishment that is meted out. In addition to all of that, we are working on sentencing guidelines. I suspect that you are reading sentences being handed down by our courts, and you, like many other members of our society, have observed sometimes inconsistent sentences, sometimes sentences that you may consider to be irrational. Sometimes you are faced with sentences that are either too high in some instances or too low in some instances. Well, sentencing guidelines that are under preparation are intended to bring greater consistency to sentencing and to bring a regulatory framework in place, which one can only hope will bring consistency and reasonableness to the regime of sentences currently being handed down by our judicial officers.
Would this take into consideration that punishment should fit the crime or should fit the criminal? How you reconcile that two?
No, punishment must fit the crime. Whoever the criminal is should only be, in my view, a factor in mitigation. But it is the wrong that is committed that will remain the wrong. If a pandit does it, or a serial killer does it, it doesn't change the wrong. If a pandit does it, and he has no antecedent, no criminal background, then that may be what you call a mitigating factor, as opposed to a serial murderer committing another murder. You follow me?
Yeah.
But emphasis should be against the wrong and not necessarily the wrongdoer.
There's another observation I make, and I have some experience about this, that the courts have been using probation reports primarily for juveniles, but for adults, they have been rarely using it. Given the philosophy of punishment for deterrence, reform, to expiate or expunge your guilt, etc., or self-defense, whatever may be the philosophy, don't you think that you need to, the judiciary need, I don't know whether you do the true constitutional or you will incorporate it in the sentences guideline or how you will do it, but I think that to develop a good sentencing policy, you also have to look at the philosophy behind punishment or sentencing, where you want to go, whether you want to do a reformative regime to
Doc,
compensation, etc.
Let me get to what you want me to answer. So the approaches to crime and criminal conduct, like everything else in human life, has undergone changes. At one time, it was felt that penal sanctions, harsh penal sanctions, was the order of the day. That approach no longer pervades. You have more what is called scientific approach to punishment and sentencing, with greater emphasis being placed on rehabilitation rather than punitive sanctions. That is why we are introducing concepts such as restorative justice, where there is a movement away from an custodial sentence and towards the imposition of non-custodial sentence, with a heavy emphasis on reform and on repairing the relationship that may have led to the crime. In other words, going to find out what was the sociological and socioeconomic factor that may have triggered the deviant conduct, to use sociological language, and that led to the crime. So that the perpetrator, after serving a sentence, doesn't go back into that very society and into that very home where the root cause that put him in the jail still continues to exist. This modern approach allows for the going into the root cause and uprooting it, so that when the person is rehabilitated or reformed and they go back there, they don't go back to that poisonous, toxic environment. So that's one thing. The other issue is you have a set of penalties, and based upon the level of crime in a society, that the society itself will press and put public pressure for there to be harsh penalties. In a crime-infested country like Guyana, you still have a strong public appeal for that penalty to be imposed and for people to be executed. Why? That is a direct result of the level of criminal conduct, in particular violent criminal conduct in the country, which continues almost unabated. In recent times, you have had some reduction. So you have to continue to be alive to your society's needs. But you have an approach that can marry the two. And that is the one that perhaps you are referencing, where you have the social people coming in, the therapists, the social workers, the probation officers, who can lend therapy, who can prepare reports, who can do evaluations, who can recommend a different form of social rehabilitation and administer them and monitor them, and that can lead to a new human being emerging from a criminal trial. So we are building systems like that, and we are investing heavily in capacity building, training people. The new prison centers that we are creating now and establishing have those facilities within them. We are building, for example, a joint electronic database that joins the DPP, the police force, the prison service, the attorney general chambers, the entire court system, the social services ministry, into one massive case management network for the sharing of information for the criminal justice system, so that magistrates now can type in and they can get a whole update now on where a person is, what antecedents the person may have in the criminal justice system, and that can inform them in the manner that they behave. How many charges are pending in the system? You know, you may be in charge, you may be facing a court charge, a criminal charge in Georgetown, but you have two others somewhere in Monkey Mountain in Region 7, another one at Aishalton, another one in Region 1 at Port Kaituma, etc. All of that we are hoping to integrate into the system and make accessible to the important players that will be using that system. All that is intended to bring greater efficiency and also to modernize the criminal justice system so that we continue to embrace new and evolving changes, while at the same time we maintain traditional methods of punishment that are considered by our population to be appropriate and relevant still.
Okay, thank you, AG. My other question related again to the Constitution. You said for there to be a constitutional amendment, you need 2/3 majority in Parliament. But these are really for the entrenched provisions of the Constitution, right? Because other amendments could be made just with a simple majority.
Well, all the important provisions of the Constitution are entrenched. If they were not entrenched, then it would make a mockery of constitutional democracy. If we could have made changes, for example, with a simple majority, we would have made sweeping changes to the Constitution. So would any other government that goes into office. So any constitutional provision of substance is heavily entrenched and would require a 2/3 majority. Very few require a simple majority to change. And in fact, they are not even worth changing.
But the question is this, if sovereignty is derived from the people, shouldn't you think that any constitutional change should go via a referendum? Because in the States, for example, any constitutional change has to go by way of special motion, election, where they got to vote on it.
No, I'm not, I don't pretend to be completely familiar with US constitutional law and constitutional system, but I don't think every provision in the US Constitution requires referendum for change. I don't think so. Important one does, and so does our Constitution. That is why when that's how the Caribbean Court of Justice ruled in the matter of Richardson. Remember the third term case? It was being argued there that referendum, there was an argument about referendum in that case. But the point I'm making, though, is that when you have the entire Constitution that will be under review, that is, and public consultation will determine the manner of change that is going to be effected, then that is like a referendum. But if it is that the Constitutional Commission decides that changes are going to be made or by referendum, well then we'll have to, it's open to that. It's open to that. But the thing, the provisions that require referendum change are really like, if you want to abolish the judiciary and that kind of thing. You know, I mean, those are really, really far-reaching changes that will require a referendum. Not many provisions in the Constitution require a referendum.
Okay, Mahendra, thank you, AG.
Thanks, Attorney General. Attorney General, under your stewardship of the Ministry of Legal Affairs, we have seen a transformation with many, magistrate courts, etc., being built across the length and breadth of Guyana. And you spoke about the digitalization of the system. Are you also considering, with respect to these buildings, to have the right infrastructure for prevention against fire and all of these things in the immediate term, as we're seeing an uprising and sort of these fires in the city, the capital city, and many of these court systems, their paper trail is so heavy. How quickly is that doable in this comprehensive restructuring?
Well, I have often outlined that, like every other area of human endeavor in Guyana, undergoing a transformation, the legal and judicial sector will not be left out. So as we are transforming infrastructure in the country, as we are transforming the social beneficial landscape, as we are transforming the agriculture sector, as we are transforming the various economic and productive sectors, we are also transforming the judicial and legal sector. Because I believe that no modern society can be built without commensurate legal foundation. In fact, it's the legal foundation that will allow for the edifice to arise that will see the transformation of Guyana. So yes, we are transforming Guyana, both in terms of the type of laws that we are passing, also in the type of systems that we are introducing, a modern form of settling of disputes like modern arbitration legislation and infrastructure. We are also creating the basis for many of the new modern industries to spring up. We can't be offering food security to the Caribbean without qualifying ourselves legally to produce and export food at the acceptable international level. You anytime you deal with food, and you have to meet certain international requirements. So it's the law that has to take us there, modernizing the infrastructure, having a legal landscape, being able to offer data protection. If you export a piece of meat, you must be able to trace it back to see which farm it came from, which animal it came from. If someone got some kind of rare disease later down the line, these are the kind of international legal requirements that have to be put in place, which we are working on. And I just give you one example. We are doing that in almost every sector. So we have to build, we are building new roads, we are developing new housing schemes and new housing areas. Every one of these places and these new developments require places where people can go and have their disputes resolved. That's an important part of everyday life. or else persons are going to take the law into their own hands and you will descend into anarchy. And that is why the law and order is that glue that keeps society together. So back to the very simplistic question you have asked me. So we are doing all of that. Whether we are building courthouses that are going to be protected from fire. Certainly, we are moving away from wooden buildings. All the courthouses that we are now building are being built in concrete. They are modern structures. They have living quarters where magistrates and court staff are going to live. We have elevators. We will obviously have to have guards, but yes, we are not building with wood anymore. It's not durable and it's not cost effective.
Yeah, AG, before this slip me, let me just ask you, this commission that is set up with 50% MPs and 50% others. Now, I don't know what direction they get or what is their mandate. Is it only to focus on constitutional reform or amendments, or is it you're given an thought to consider there may be a need for a new constitution?
That's what constitutional reform is. If they decide it's a new constitution, then it's a new constitution. But Doc, people believe constitutional reform is a very sexy thing, in modern politics. A lot of people clamor for constitutional reform. And I really don't, sometimes I wonder, what do they want to reform? We have today, and I've said it over and over again, and I will debate this anywhere, we have one of the most modern constitutions in the English-speaking Caribbean. One of the most embracing constitutions. There is no other constitution in the English-speaking Caribbean, and I go as far as say in most Commonwealth countries, that share power and devolve power in the manner that this constitution does. Devolve power and share power between the executive and other organs of state, including the opposition. That 1999-2001 constitutional reform, that was a constitutional reform process that broke the back of what was then known as the Burnham Constitution. Over 200 changes were made. Sometimes we don't speak about these things, and people think that we have the Burnham Constitution still around. We don't. We have a liberal, modern constitution. I hear a lot of people talk about the powers of the president. The powers of the Guyanese president is similar to the powers of the Trinidad president. And the Trinidad president is ceremonial. The Guyanese president is executive. The regime of power that our president has, the same regime of power the United States president has. And the same regime of power that every Caribbean head of state has. It's the powers that goes with the head of state. Now look at the way our Chief Justice and Chancellor are appointed in Guyana. Both require an agreement between the leader of the opposition and the president. There is no other country on planet Earth that has a constitution that has that requirement. We have a parliament that has a very vibrant standing committee system where you have a whole set of committees: Economic Service Committee, Social Service Committee, Foreign Relations Committee, Public Accounts Committee, Natural Resources Committee, a Standing Committee on Constitutional Reform. These committees are all empowered to review various aspects of governmental functions, as their name suggests, and to summon ministers before them, and to summon public officers to answer in any area of responsibility within their respective ministries, and a power to order investigations. And these are not committees that are chaired by ministers. These are committees that are chaired by the opposition. You don't have that in other parliaments in the Caribbean. And I can go on to show you the powers that our Auditor General has. That plenitude of power is not there in the Constitution. We have a series of constitutional commissions which do not exist in other constitutions. All they have is the Police Service Commission, Public Service Commission, and Judicial Service Commission. We have things like Ethnic Relations Commission. We have an Elections Commission. We have a Rights of the Child Commission. We have an Indigenous People Commission. We have I can't remember, a whole regime of commissions, each being appointed not by the executive, but through a parliamentary process. And they hold important constitutional jurisdiction and power over whole different areas of national life in this country. So it's not about getting a new constitution and making constitutional changes. While I am for that, because I believe the constitution must remain an organic document, it must remain alive, it must remain dynamic to meet the exigencies of a changing and evolving society. I don't believe that we should use the constitution as the panacea to solve other problems. You have a bunch of politicians in this country who can win political power through the ballots, and they always blame the Constitution. Every time the PNC lose an election, you hear them shout about constitutional reform. When they won the election under the very Constitution, they abandoned constitutional reform. But now they are in the opposition, you will hear them clamor for constitutional reform, as though that will get them to win an election. The Constitution must not be the politician's zombie. This is not obia work. And it must not be the substitute for other areas where you have to really work to get solutions to problems. So all that I say about constitutional reform, I just say those words in admonition, because I observe a tendency in Guyana and among the diaspora to just clamor for constitutional reform, not even understanding what we have and what they want out of this. Some of them believe that constitutional reform will suddenly waive, once that happens, or whatever it is, and however it manifests itself, it will result in a transformation of Guyana, and it will solve all the ethnic problems that we have in the country. It will not do that. The Constitution is a book. It has to be interpreted, and it has to work.
Well,
by human beings making it work.
One of the things about the Guyana Constitution is so long and so heavy. Look, this is a copy of the U.S. Constitution, passport size 60 pages.
My friend, I read the Indian Constitution that governs 2 billion people. Is about the same size with the U.S. Constitution. It is a fraction of Guyana's Constitution.
Let me just, when you say people in the diaspora talk about constitutional reform, looking at PP Manifesto, PNC and others, all of them have in the manifesto constitutional reform, including PVP. So I get from what you're saying that I get there is not too much enthusiasm for reform, because you said this constitution with the amendments in 2001 is good with all these committees.
No.
So why is it in the beginning
the PP incorporate? Listen, I have expressed a view, as I said at the beginning of the program. The PPP is not going to engineer or impose its views. We believe that the population should speak. I believe that there are certain parts of the Constitution that have to be amended. There are portions of it that have not worked. I mentioned a couple of them tonight.
Okay.
And they will not work in the near future, in my view. I am only a citizen. and I'm entitled to that view. That's not necessarily the government's view.
Mhm.
But I do not lose my right as a citizen to express my view because I have become a minister. But
Okay.
constitutional reform is a promise that we have made, and we will work towards delivering.
Okay. I want to get it clear, to get it in perspective. I'm glad you clarified it. Mahendra, you have a final question?
Yeah, and thanks, Attorney General, for clarifying, that this infatuation with the constitutional reform. But Attorney General, you alluded to this not being a sexy notion of constitutional reform.
I know I said it is a sexy notion.
Is a sexy notion. My apologies. But if what is maybe two of your priorities in this process, if you had to list two priorities in the constitutional reform, task?
Two priorities. I believe that there are a lot of excesses in the Constitution currently that should be deleted. It would be too much for me to go in to what those are, but there are a lot of surplusages. You see, Dr. Tara Singh upheld just now the U.S. Constitution. No one can question U.S. democratic credentials, in particular, their commitment to their constitutional rights, whatever those rights are, including the right to bear arms and so on, something that I don't necessarily agree with. But they revere those rights. And they express it in simple language and with as limited words as possible. We have a lot of excesses in terms of language that sometimes obscure and render ambiguous the purport and intent of our Constitution. So I would like to see that kind of cleansing process. The second thing is, I would like to see a review of provisions in the Constitution that have not worked. They must be reviewed. It makes no sense, in my view, in becoming idealistic to the extent that you have become unrealistic. And you put provisions in the Constitution that will never be able to be implemented. And when that happens, it causes more damage to the fabric of your Constitution, to constitutionality, and to the rule of law more than anything else. Those aspects of it must be reviewed. And I believe that your Constitution should only embrace the absolute vital issues that should be constitutionalized. Putting too much in the Constitution trivializes your most fundamental law. Rather than make it sacred and sacrosanct, it dilutes it, because you have all sorts of things in there that detracts from the core constitutional values and principles, concepts and precepts, which you should have ensconced and make clear with explicit and simple language. Those are some of the important issues that I would like to clarify. And I mean, those they cover a lot of areas.
Would you also emphasize constitutional compliance as one of your priorities?
Well, I have always said
when I say compliance, let me just clarify it. You can violate the Constitution, but there's no penalty for you. Would you build in penalties for violations?
Now, the Constitution, first of all, without constitutional compliance, it makes no sense that you have a Constitution. It makes no sense having a nice, glossy-looking book called a Constitution with the highest sounding ideals ensconced firmly within it, and nobody obeys it. That's a complete and utter waste of time. So constitutional compliance underlines constitutional and underlies constitutionality and the rule of law. That's the first thing. Secondly, what was the other part you asked me?
The penalty for violation of a constitutional provision.
The Constitution, by its nature, it's not a criminal statute. So its violation will not carry penal sanctions. It will carry repercussions of a political and public nature. And perhaps one can look at that. For example, you commit constitutional violations, you become disqualified from holding any office under the Constitution in the future. And that can be a recommendation that one can adopt and allow that to run throughout the Constitution. Impose strong, not penal sanctions because you don't have the ability to. The document is not of that jurisprudential genus, but it can have its own regime of sanctions of a civil type of nature.
Yeah. Okay, thank you. We are out of time, but so thank you, AG, for these are issues that people raise with us. So when we ask you questions, it's not necessarily our views. We are just reflecting the views of a cross section of the people here.
Well, I hope that I have answered those.
You have clarified many things, which I'm sure the viewers, including us, have a better understanding of what's going on. Shamisa, over to you.
Thank you, Dr. Tara. Honorable Minister, we will now take a couple of questions from our viewers. Our first question comes from Kevin Samaru from Toronto, Canada. And his question first, he says, greetings, Honorable Attorney General. Can you give light to the proposed penalties on person or persons who are involved in or attempting of elections rigging?
Well, that is quite a topical question from Kevin Samaru from Canada. Now, I know that Kevin Samaru has been following the events in Guyana very closely on Facebook. And he would know that we tabled and passed in the Parliament last year 2 sets of statutory reforms one to the Representation of the People Act, and second to the National Registration Act. A total of dozens of changes we made to those 2 important pieces of electoral legislation. Included in those reforms are a series of penalties created, some of them new, some of them old, new offenses created with very, very heavy penalties, including life imprisonment, 10 years as the case may be, different depending upon the gravity of the wrong. So we have a regime of sanctions that are strong, that are very punitive, and that ought to act as a serious deterrent for activities relating to compromising legitimacy of our elections.
Okay. He also asked why is there a 2-term limit to the head of state in the Guyana Constitution? Almost all countries in the Commonwealth, including Canada, India, England, and many other countries, do not have such clause in their constitutions. I think Guyana Constitution for this 2-term limit should be removed in the revised constitution.
Well, it is the constitutional reform process that put that there in the first place. recall in 1999 to 2001, we did constitutional reform. And out of those reforms, out of consultations, came at the two-term limits. We are going back to constitutional reform, and if the people feel that that should be dispensed with, then it will come out in the consultations that will pervade that process.
Thank you very much, Honorable Minister. Thank you, Dr. Tara. And thank you, Mahindra.
Thank you.
Thank you to all our viewers.
Would you ask the minister to make a closing statement?
Minister Nandlall, can you give us your closing remarks?
Well, I want to thank you very much for inviting me to be part of this engagement. I think that we have had a thorough and very interactive exchange. I am happy that I have addressed many concerns that Dr. Tara Singh and Mahendra Hariraj have expressed. And I'm also happy that they have conveyed to me and on the program many questions that would have been posed to them in the diaspora, because these exchanges are important to get our views out there, to have a healthy exchange of views, freedom of expression, and our government remains accessible to the people are all important tenets and components of our democracy. Ours is a style of government where we continue to remain attached and closely connected to the people of our country, wherever they are located. The diaspora, as we have often said, is an important developmental partner. You have partnered with us in the good times and in the bad times, and we have developed great relationships with you, and we would like to continue these relationships, and we would like to continue to be interacting and interactive with you. I want to take this opportunity, Shamiza, Dr. Singh, and Mr. Hariraj, to thank you very much for hosting this program and for providing this important platform that allows our leaders, our ministers, and members of our government and members of the Guyanese community to interact with the diaspora and to interact with you. You are doing a tremendous job, and please continue to accommodate us on these platforms. And I'm sure my other colleagues will join you, and I will join you again in due course. And I want to thank the sponsors, Dave, and all those whose sponsorship have made this platform possible, and I encourage them to continue to do so.
Thank you very much, AG. This was a very excellent session, and we thank you as usually. You're erudite and very knowledgeable in these areas, and we are very happy to have you, and thank you for making this time possible.
Thank you very much.
Thank you. Thank you. Good evening, everyone. Until next time, this is the Guyana Dialogue, and I'm your hostess, Shamiza Ali. Good evening.
Good evening.
Good evening.
Thank you, AG.